McLeod, the Director, and Mr. Charles Dent, Chair of the Human Rights Commission. I'm happy to see we're joined by some members of the public. We will not be allowing public submissions at this time, as we are here solely to discuss the Human Rights Report. But of course, committee always welcomes public input and participation when we create those opportunities, such as in the review of legislation. With that, I will turn to committee members to introduce themselves for the record. We'll start with Mr. O'Reilly.
Kevin O'Reilly, Frame Lake.
Michael Natalie, actual.
RJ Simpson, I'm Deputy Chair, and I'm the MLA from Hay River North.
And I am Kieron Testart, Chair of the Standing Committee on Government Operations and member for Cam Lake. And with me at the table are Ms. April Taylor, Research Advisor, and two clerks today, Ms. Jennifer Franki-Smith and Ms. Gail Bennett. And with that, we'll turn the floor over to Mr. Charles Dent to present on the 2015-16 and 2016-17 annual reports of the NWT Human Rights Commission. Mr. Dent, you have the floor.
Thank you, Mr. Chairman. We appreciate the invitation to appear today as you review the NWT Human Rights Commission's annual reports for the 2015 and 2016-17 years. Our 2015-16 annual report confirmed our observations that the human rights system of the NWT had become too complex, too legalistic, and very hard for people to use unless they had a lawyer to help them. The key recommendation coming from the report was the entire system should move to a restorative approach with a simplified structure so people could better understand our processes and use our services. The report also said that the Commission should put more focus on broad systemic issues and that we should find ways to work with Northern residents and community groups to foster a culture of inclusion in the Northwest Territories. Throughout the 2016-17 year, the Commission spent a significant amount of time exploring how we might approach issues of systemic discrimination in the NWT and working toward the implementation of a more restorative system. To this end, the Commission invited Dr. Shaheen Azmi of the Ontario Human Rights Commission to Yellowknife to introduce members of our human rights system to ways of diagnosing institutional systemic discrimination and to discuss ways Ontario identifies areas of public interest and how they approach systemic advocacy. We continue to build our relationships with Northerners using social media to engage people in NWT communities. Our Facebook community has grown substantially over the past 2 years, from just over 500 followers at the start of the 2015-16 year to over 1,540 followers at the end of the 2016-17 fiscal year. We have followers in 27 of the 33 communities in the territory. Our Facebook page offers information and resources about human rights in a positive and engaging way. We also redesigned our website and print resources to make information on human rights in the NWT easier to find and understand. Finally, one of the most significant and important issues arising in 2016-17 was the release of the calls to action from the Truth and Reconciliation Commission's report. Our commission met with TRC Commissioner Marie Wilson in September of 2016, where she made suggestions regarding our strategy for supporting the reconciliation work, which is an essential part of our restorative approach to human rights in the territory. Thank you, Mr. Chairman. We're now prepared to answer any questions the committee may have about our annual reports.
Thank you, Mr. Dent. Committee, I'll now open the floor to questions or comments from committee members. We're going to approach a 10-minute block for committee members to ask questions. It'll be a free exchange of information. So, Mr. Dent and Ms. McLeod, if you are called on by a committee member, the mic will turn on and you can just comment directly. There's no need to wait for me. I will only intervene if we need to get back to order or if a member's time has expired. And with that, I'll turn to committee for questions or comments. Mr. Simpson, you have the floor.
Thank you, and thank you to the witnesses for being here. This year I had the opportunity to assist one of my constituents with a complaint to the Commission, and I have to say that the process, the person at the Commission was very, very helpful, and they kept us informed of what was going on the entire time, and was a great, was always quick to respond and let us know what was happening. The constituent I was dealing with maybe had low literacy skills, and I'm wondering, how is the Commission I believe there's an office here where someone can go and sit with someone and they can assist. But for people wishing to make a complaint outside of Yellowknife, and if they do have low literacy skills, how does the commission assist them with the application process? Because, you know, there is a paper form that needs to be filled out.
Thank you for the question. We spend a great deal of time with people, assisting them. The human rights officer will help them write the complaint, will talk to them about the process, and will fill in the complaint for them, and then send it to them and help them in any way. The human rights officer will also assist in the process in assisting people with low literacy skills to respond to the responses from the respondent, from whomever the complaint has been against. So we spend a lot of effort at our end of the process, the early complaint process, to assist people in that area. We also are doing more work face-to-face through video conferencing as well as by phone, and we find that quite helpful as well.
Thank you for that answer. So someone could phone up the office, and the person on the other end would fill out the form for them, you know, from start to finish. Does it have to be mailed for a signature, or are there any sort of technicalities like that need to be dealt with, or can this be dealt with completely over the phone?
It can be dealt with completely over the phone. We would prefer them to sign the document and send it back, but they can fax it back, they can scan it and sign it and scan it. So we're willing to work with people in whatever works with people's circumstances.
Thank you. I had another question about outreach. I know the commission does lots of outreach to communities, and this came up this year in Hay River and was actually related to the complaint that I was helping with. We don't have a company that pours concrete essentially in town, and so when someone comes into, a company comes in to put down sidewalks, everyone in town who needs concrete poured gets it poured then. And so what happened was, for the first time in probably 40 years, the sidewalks downtown were redone. And it was a perfect opportunity to address some of the issues in that town when it comes to mobility. I mean, a lot of the buildings downtown were, 40, 50 years old, and there's a steep step to get up into a lot of them. And this could have been addressed by, forming the concrete to make it easier for people with mobility issues to get in there. And this was raised with the town of Hay River after. I raised it with them because I wasn't aware of, or actually I believe my CA did, because I wasn't aware that, this was happening. So was that the kind of outreach that the commission would do, is go to the communities and let them know that, or give them ideas about what they can do on an ongoing basis to avoid some of these human rights complaints?
I think, yeah, I mean, that's a really good idea. I don't know if you know, about 3 years ago, a Hay River company was actually given a recognition, the Human Rights Accessibility Award, which we presented, because they did just that. They provided a ramp where there hadn't been one previously, and they were nominated by the Hay River Committee for Disabled People. So, and the reason we do that sort of program, that award program, is to try and highlight and bring attention to the fact that it doesn't always cost a lot of money to make those improvements that will be or will make a significant difference in somebody who has reduced mobility. In terms of specifically reaching out and advising people to watch for opportunities like that, I don't think we've actually sort of contacted communities and suggested they do it. It's a good suggestion. It's something we'll take a look at whether we can work into our outreach.
Thank you for that. And I know that I know you have a limited budget, and you can't be everywhere, but I think contacting the municipalities, and from there they can perhaps take it and let the businesses know if they're getting their sidewalks done or they're having renovations, that to keep in mind those accessibility issues. You spoke of moving towards a more restorative approach, and I was wondering if you could elaborate a bit and maybe let us know how it would be different now than it would be maybe 2 years ago if someone brought a complaint forward.
Deborah?
So So there's a lot of work to be done to make our entire process more restorative and for us as a commission and as a system to work in a more restorative way. However, we've not waited for changes in the legislation to begin to make changes in the complaint process. Early last year, my office began to work more restoratively within the complaint process. So we'd had some training. We had a better idea of what a restorative approach would look like. And we decided to start shifting the complaint process, not the process itself, but our approach in the process. And actually, we're seeing what we believe are really some promising results as a result of that. We began by using a more restorative approach when we served complaints. So when we get a complaint, we would take and call up the respondent. And what we would usually do is we would talk about, okay, you have an allegation against you. This is what the process looks like. We're going to send you some information. Then you're going to have a month to respond. And, you know, the back and forth of a legal complaint process. What we started doing was using that call as an opportunity to make a relationship with the respondent, with the employer or the service provider. We started talking about you're going to get this information, and when you've had a chance to look at it, call us back and we can talk about various ways that this complaint could be resolved. And by shifting that language and talking more face-to-face with the respondent, rather than just saying, no, quickly find a lawyer and make a response, we're saying, like, take a look at it and then we'll talk, and we can make our process work, you know, for the parties. So in the 2 years previous, we had take up on our mediation process, I think about 9 or 10 files, took mediation, tried to resolve things through mediation. In the first 7 months that we started shifting our language and starting this sort of shift in process, we had 26 uptake in mediation. When the HRO, the human rights officer who is doing that work, I think something shifted so that we weren't doing it quite so much, it immediately dropped. So we're taking this as a very promising sign of what might be a way of assisting parties to work together to resolve complaints early on in the process. What we're doing now is, now that we have that idea about how that works, we're stabilizing the process by you know, designing scripts, doing more training, developing our paperwork to be more consistent with that process. So we haven't waited, and we think that it's showing already some promising results.
Thank you for that answer. It's good to hear that things are happening now and you're not waiting for changes to legislation. And the issue that I was dealing with ended amicably, and both parties involved, I think, are probably moving forward, are going to be better off. So what you're doing to implement this restorative process, is that going to change the amendments that the Commission has proposed for the Human Rights Act? Or is everything going to remain the same, essentially? Thank you.
When we proposed the amendments, we had in mind already that we were going to move to restorative process. So some of the amendments are required for us to absolutely, or to go all of the way that we want to go in the restorative process. So no, we haven't, obviously we haven't seen the final legislation yet, but we did, we were given a very good opportunity to work with Justice on the legislative proposal, and so we have a pretty good idea of what it should be, it should reflect. And if it does reflect our expectation, then no, it will help us get to where we're trying to go.
Thank you, Mr. Dent. Mr. Simpson, your time has expired. I will now move to Mr. McNeely. You have the floor.
Thank you, Mr. Chair, and thanks to Chair for this report here. My question is related on the last paragraph. of your presentation on the Truth and Reconciliation. In your 2016-17 annual report talks about the work that the commission is doing in understanding and implementing the findings of the Truth and Reconciliation Commission report. Can you elaborate a little bit more on what you mean by that? What efforts, for example, are both the commission and, say, Susan or Marie Wilson's role on behalf of the TRC working together? Thank you, Mr. Chair.
Thank you for the question. What we did was we invited Marie Wilson to meet with us for a morning to help us work at developing our strategy for incorporating the calls to action in our work as we move forward. And some of it's pretty simple. For instance, we had a session this morning, and we opened with recognizing that our work is being done on the traditional lands of Chief Dry Geese in the Acacia Territory, and that was because the meeting was here. So, but what we try and do is work things into, or we try and keep the calls in action in mind as we're going ahead. All of the members of the commission have participated in the training program that was developed by ECE, and we still have a long ways to go at sort of a formal program for how we incorporate the calls to action, but we are committed to moving forward to incorporate them into our work. Do you want to add anything to that?
No, but our December 10th as well.
Yes. I was reminded by Ms. McLeod that we've focused our annual, we do one sort of annual event a year, was focused on reconciliation, and we brought in people to talk about that.
Yes, thank you for that clarification on advancing forward initiatives. Is there any plans moving forward to have that type of session in the smaller communities or in other regions? Thank you. We try to when we're in a smaller community, when we visit the smaller communities, we don't get to a lot of them every year, but we do try and get out to the communities regularly. Any of the public events we have, we would certainly make sure that we're being careful to reflect the calls to action. Nothing further. Thank you, Mr. Chair.
Thank you, Mr. McNeely. Mr. Riley, you have the floor.
Thanks, Mr. Chair, and thanks to our guests today. I just want to go back to the discussion about restorative justice, and look, I think if we can get people talking and working things out, that's great. But I think there's probably a small number of cases where you still need to adjudicate, and it's still going to require an adversarial approach to inquire, test information, and so on. So is that still going to be an option moving forward? Is that still going to be something that we would need as an option at some point, perhaps?
What we've discovered is that a restorative approach isn't a model that has a strict set of parameters and follows a set guideline. And I think, as you heard from Ms. McLeod earlier when she was talking about dealing with respondents and how a different tone of dealing with respondents has made a dramatic difference in the way complaints are being resolved. So it's almost like a one-off. Every complaint has to be dealt with in an individual manner, and what is appropriate in one case may not be appropriate in another. And that's part of the restorative process, is recognizing what you do to move forward. The adjudication panel has, under our legislation, the right to set their own rules and processes, so I can't really speak for the adjudication panel. But I do know that in talking to the adjudicators, because we work with, we have a three-way working group where the adjudication panel, the commission, and the director's office all meet regularly to talk about what we're doing, that they are seriously looking at a different style. Perhaps one that is, one of the things I've talked about is looking at a style of adjudication that is similar to what was used in the Indian residential schools adjudication, where it was adjudicator-led, which is a much different process than adversarial. So you can still have that, that fairness in law without having a situation where you are completely at loggerheads with each other. And I think that's where they're going, but I can't, again, they set their own rules, and I know just from conversations that they're looking at that sort of approach.
Thanks, that's really helpful. But the commission's not necessarily recommending that we get rid of the adjudication process and completely replace it with a restorative justice approach. And I don't think they're mutually exclusive, as you've said, but I still, I just want to make sure that there's still a time and a place for adjudication in the process of resolving these complaints. Thanks.
No, when you see the legislation proposed, I don't know if, or you may have seen it, it's not recommending any changes like that to the, so there would still be an adjudication panel, and they would still be setting their rules. But I think that the goal is, and I think the adjudication panel agrees, that it makes more sense to have a restorative process through the whole system. And I think they believe that you can have adjudication that is restorative.
Yeah, thanks. I appreciate that. I think probably want to make sure there's enough flexibility to handle a number of different situations, and I think that's probably a good thing. And I am encouraged by the fact that more complaints seem to be headed to mediation than a full adjudication. I think that's a good sign as well. So, I think things are heading in the right direction. But I want to just ask on a couple of other areas. I understand that the commission is looking at additional grounds for discrimination, or adding some grounds for discrimination. Can you just tell us a little bit more about that? Thanks.
Things change over time, obviously, and one of the practices that some jurisdictions are looking at, Canada and some areas, for instance, are genetic issues and discrimination because of genetic issues. So that's one that we have had some discussion about. It's not one that's likely to be in the legislation that's coming forward, but we are always looking at different areas that we look at what other jurisdictions are doing. We look at what's common in the world of human rights, and try to make sure that our legislation is keeping up. At one time, when it was introduced and passed, it was probably the most progressive in Canada, and we want to make sure that we're not falling behind. So we're constantly looking at different things to add to, or to suggest to the Legislative Assembly should add to the legislation.
Okay, thanks. Yeah, I think those are good points. So just on the issue, though, of genetic issues, does this arise from insurance companies declining coverage because of some genetic predisposition or something? Is that, I'm just trying to understand the context here. Thanks.
That would be one area that would lead to this being an issue, yes.
Okay, thanks. Yeah, I think any advice or suggestions on those emerging areas would be really helpful for us to understand, which sort of gets into the next question I have, which is about how you collaborate with other jurisdictions. I noticed that, and I confess I don't know much about this, but is there a national level or organization where human rights commissions get together and talk about emerging issues and do professional development, that sort of thing? Thank you.
There is, it's called CASHRA, or the Canadian Association of Statutory Human Rights Agencies. We meet by teleconference typically monthly, and we have generally 2 face-to-face meetings a year, one typically in June and one typically in November, early December. And I'm actually the president, or no, chair of CASHRA right now.
Great, thanks. I don't know, maybe you can just tell us a little bit more about what sort of things we are able to share with other jurisdictions where we may be at, or some areas where other jurisdictions may be seeing issues or that might come to our doorstep at some point. Thanks.
Typically, I mean, one of the best things about an organization like that, particularly when you've got the different approaches across the country, because no 2 jurisdictions have human rights legislation that is the same, is the sharing of ideas. So, you know, we were able to talk to the people from Nova Scotia about what a restorative process might look like and get some ideas from them. We've been able to learn, in particular, from the mistakes they made in implementing and avoid what we think were some of the mistakes they made. People have, you know, in terms of grounds, that's certainly an area that we all talk about. And as grounds change across the country, there's a fair bit of catch-up and Me Too that goes on. But that's where we first generally talk about it. People will say, are you starting to see people coming in and talking about this? And is this an area that's becoming more and more of a concern? So it becomes a bit of a sounding board. It's really, I think, quite useful in terms of sharing information. That's the biggest value that I think we have for an organization like that.
Great, thanks. Yeah, I encourage you to keep up those contacts and networking. That's really good work. I don't have any other questions, Mr. Chair, but thanks very much to our guests for appearing today.
Actually, I'll just ask a few questions myself before turning to other committee members. Mr. Dent, what are the most frequent grounds for human rights complaints captured in both of these reports?
Disability.
Would you, how would you characterize the current systems that are in place as they relate to, or government systems in place as they relate to disability supports or rights for the disabled? Do we have an issue, a systemic issue that we need to look at as a government, or are these just par for the course with human rights commissions across the country, rather?
Well, it's, I think, all across Canada, complaints related to disability tend to be at right around 50% of all the complaints that are received by commissions. But there's no way of knowing for sure what the issues might be. It could be, for instance, that a complaint that is race-based is much more difficult to prove, much more difficult to see a result from, so we don't tend to get as many race-based complaints. I think we are a little surprised at the low numbers of race complaints that we see. It could also be things like, you know, the government does have a role to play in things like the building code, and a lot of people don't recognize that the way human rights has developed in the past few years means that we have buildings that aren't necessarily accessible, even though they are approved by the building code. So there's a big difference between a building that meets building code standards and one that is actually accessible. And I think governments have a responsibility to try and resolve that. I think that we should start to see building codes that do actually mean the environment is suitable, it's built in a proper way for people who have mobility issues and other challenges.
Okay, thank you, Mr. Dent. Has that issue been raised at the national level with the National Building Code resting with, of course, the federal government? And, you know, like, is this a common concern across the board that is being addressed?
It's common in many areas, but remember, building codes are adopted by provinces and territories, so it's actually the province or territory that's responsible for the building code. Ontario probably has the lead right now. They've got legislation in place that requires changes by, I think it's 2022, something like that. So they've passed legislation that will require buildings to actually make changes to meet a higher standard. And what they've moved to as well is making sure that that there's an understanding among builders that and they're bringing their building code together with the built environment and what needs to happen in the built environment to be accessible. It's a phased-in approach. I think it's taking to the mid-20s before they're actually going to get there, but at least they have started the process to get there.
Okay, thank you for that. Moving on to another topic, in your 2014 comprehensive review of the NWT human rights systems and legislation, you note that, and this is in the 2015-16 annual report, you know that more work needs to be done, or the Commission notes more work needs to be done to identify and address system discrimination. Can you elaborate on that recommendation, Mr. Dent?
Sure. For most of the history of the NWT Human Rights Commission, it's been focused on individual complaints and resolving individual situations. But an institution like a Human Rights Commission should focus more on the broader strokes, should be on areas that are systemic. So you asked about systemic issues in things like the building code creates a systemic problem. That's something that the Commission should be more focused on, because resolving a systemic issue will solve more people's problems than just dealing with complaints one by one. So the goal is for us to become much more focused on systemic issues and you know, not abandon the individual complaints area, but where it makes most sense to resolve or to resolve the most issues is to move as much as possible into systemic issues.
Do you have any kind of concrete steps that can be taken to allow the Commission to do that work? Is it all tied up with the legislation, or are there other improvements that could be made to allow you to do that kind of systemic review of issues?
No, we don't need to wait for the legislation. We've started. In the first 10 years of the existence of the Commission, they really only got significantly involved in one systemic issue, and that was the Mercer case. That took about 10 years. In the last 2 years, I think we've actually involved council in either 7 or 8. So we have started to move already, where we are taking on issues that we see as systemic.
Okay. Thank you very much, Mr. Dent.
If I could add one thing,
you
Mr.
may.
Testart, one thing that actually will help us significantly move in that area is to bring a lawyer in, and that is included in the Legislative Assembly budget for next year, because what that means is then we'll have somebody in the office that we can work with on a regular basis to when we're made aware of systemic issues, then it gives us a better tool to work with to start to address them.
Thank you, Mr. Dent. And I think, speaking on behalf of committee, we are always very impressed with how proactive the Commission is in handling its role, and we do appreciate you're not waiting for legislation, you're taking what action you can take. I'll give the floor to Mr. Simpson.
Thank you, Mr. Chair. I've had a constituent raise the issue of the threshold with me. It is noted in the annual report 2015-2016 as well that the threshold for complaint is too low. What is Since this is a public briefing, the idea is to get the information out to the public. Can you maybe discuss the issue of the threshold and what the commission is proposing to change about it?
Well, that is one thing that needs to change in legislation, so the commission can't change that. But what this would do, it would mean that that if you raise the threshold, right now, let me go back. Right now, the threshold is so low that almost anything, as long as it's sort of on the balance of probabilities, if one side of the story only was listened to, there was an issue of discrimination, the director doesn't have much choice except to refer it to a hearing. So that's what we mean by a low threshold. This would, by raising the threshold, you would probably reduce the numbers of complaints that would go to adjudication, which is the most expensive part of the process. So what we're trying to do is make sure that there's more mediation that takes place, the front end in Ms. McLeod's office. It'll actually, in the long run, save the whole system a lot of money instead of going to adjudication. So we want to be able to have a higher threshold, so some complaints that now shouldn't be referred will be dismissed, and hopefully just through the office and working through the office, we'll be able to resolve them in the front end.
And so, for example, instead of just hearing one side and then referring it to adjudication, the commission may reach out and listen to the other side of the story, basically? Is that sort of the idea?
You already have to listen to both sides, but the way the courts have interpreted our legislation, they've basically said that it's nothing more than a screening process. I think that's a direct quote, isn't it? It was a screening process they used in the court decision?
What the comprehensive review said is that the threshold being as low as it is does not allow the director to properly screen complaints. So complaints are going forward that, in the opinion of the comprehensive review team, should not have gone forward. They should have been dismissed at the early stage. So.
Thank you. And another issue I have is what happens if a complaint is essentially abandoned? Say if the adjudication panel was looking into a complaint and the complainant no longer cares to pursue it. What is the process then?
Actually, just in the past couple of months, there have been 2 cases like that. And what the adjudication panel does is they call a hearing with all of the parties. And I think they do it twice, and if the second time the party doesn't show, then they can dismiss it.
And so essentially, they'd reach out to the party through newspapers or radio ads, because I know that in Hay River there was ads in the paper on a weekly basis from the adjudication panel, calling people to a meeting that no one wanted to attend, and it seemed like sort of a strange process. And
until somebody actually withdraws their complaint, then the legislation really didn't give the adjudication panel a way out. So what they did was they developed a process and wanted to make sure that it was administratively fair. So I think that required that they do some advertising. Yeah, actually, our legislation doesn't address what happens if somebody doesn't show up. So it's been left up to them to develop the rules. So they came up with a process that they thought would withstand a challenge, and then went through with it. But if the complainant had simply withdrawn the complaint, it would have been over.
And are the changes that the commission is recommending, will they address that?
No, they wouldn't, because I think the adjudication panel is satisfied with their process, that it achieves it, but, and that might be a question that you want to pose to the chair of the adjudication panel. Unfortunately, he couldn't be with us here today.
Okay. Yeah, I did receive complaints about this, and it does seem like an odd process, especially in a small community where, you know, ask someone what someone's phone number is. You can call them and say, do you want to follow through with this, instead of this big process of, you know, a big public campaign. So I guess that was my issue, and I will return to the constituent with your answer. And it's a shame that, and I guess it's the way the commission is set up. There's 3 parts. Not everyone can, you know, you don't answer for everyone. So, but going forward, hopefully these changes will remedy some of those type of issues as well. So nothing further right now, Mr. Chair.
Thank you, Mr. Simpson. And Mr. Dent, did you want to provide comment on Mr. Simpson's comments?
No, I think the committee may want to invite Mr. Toner to your meeting next year so that you can address that sort of question directly with him.
Okay, thank you, Mr. Dent. I always like to give our witnesses the last word, so to speak. Any other comments from committee or questions? Okay, hearing none, I'd like, on behalf of committee, I'd like to thank Mr. Dent and Ms. McLeod for joining us today and presenting their reports. If you have any closing comments, Mr. Dent?
I don't. Thank you very much to the committee for your attention to our reports. We look forward to meeting with you again fairly soon. We'll have our next annual report in within a few months. And we also look forward to meeting with you when you review the legislation that we're hopefully going to see this year.
Thank you, Mr. Dent, and we will endeavor to make sure our schedule allows for a prompt review of your report. We do apologize for the backlog, but you never know what we have to deal with, and sometimes committee schedule can get booked up. But with that, you are excused, and I'll ask committee members to remain behind so we can discuss the results of the hearing. Thank you.